Hello, everybody.
There are three cases before this court at this time, all state of Kansas versus Dylan Michael Fellmeyer. They are case numbers 2022 CR 490, 22 CR 462, 22 CR 460. Brett Sweeney appears for the state of Kansas. John Rapp as defense counsel. Defendant Fellmeyer is appearing in the office of his attorney. Mr. Fellmeyer, you were specifically told by this court back on January the 12th that there was one place that you were to appear for court, and that was the Judicial Center in El Dorado, Kansas. How come you're not there?
I apologize, Your Honor. I had changed counsel, and I was
Changing counsel doesn't make one bit of difference regarding what the court orders you to do. Number two, no attorney has the right to change a court's order. So if he tells you you could appear in his office, that's wrong. Your responsibility was to follow the court's order regarding your bond, and that was to appear at the Judicial Center in El Dorado.
I apologize, Your Honor. It won't happen again.
All right. This is the 12th court appearance on at least one of these cases, if not all three. These cases go back to 2022. Mr. Sweeney, do we have a resolution to announce here?
Your Honor, we don't. I would tell the court that I've taken over all of these cases now, so there's only one prosecutor involved. I will tell the court it kind of did surprise me when there was a change of counsel, so I had to switch up negotiations from Mr. Andrews to Mr. Rapp, but he may be able to tell you a little bit more about that, but we have been in discussion all week about these cases.
All right. Is there one or more cases which are outside this court's docket?
Your Honor, there's two, and then some traffic matters. But Mr. Sweeney and I had a very, very good phone conference, lengthy phone conference on Tuesday, talking about a global settlement of everything. I will tell the court that these three cases, I understand that they've aged. Mr. Fellmeyer has completed inpatient rehab. These are all part of a methamphetamine addiction and is doing well in aftercare. I will have an update that I've shared the completion letter with Mr. Sweeney. So we're on a path to resolution and getting Mr. Fellmeyer well. Which
means what, as far as resolution of these cases are concerned?
Well, I think that, as this court knows, because much of these cases are from when he was in his addiction, if he's sober, he's not going to have these problems. He's also staying away from the alleged victim in these three cases, who's also an addict. And Mr. Sweeney's reaching out to her to find out how she feels about some of the discussions we had towards a resolution, Your Honor.
Have you had those discussions with the alleged victims in these cases, Mr. Sweeney?
Your Honor, we have been in contact with the victim in this case, so she's been aware of everything. As far as specifically what we're going to do with all of these cases, because there are so many, I think we need to just tell her when we get something finalized what that's going to be. But as far as resolution today, no, we haven't finalized anything with her yet. No, she is aware of today's hearing. We've made contact with her. We've had good contact with her in the past, but I think basically what we need to do is get something finalized. I share the court's concern. These cases are old and getting older by the day, so I want to get them over with just as much as the court does. The change of counsel, like I said, did throw a slight wrench in things, and Mr. Rapp has been providing me a few things. We'll see if it makes a difference, but that's about what I have to report to the court.
All right. Well, thank you, Mr. Sweeney. I appreciate your candor. I mean, though this delay may not be attributable to you personally in the office, your office is responsible for appropriately pursuing and prosecuting these cases, which in this court's view, you have not done. Furthermore, it does appear that this last-minute change to retained counsel after all of this time and after all of the work done by the appointed attorney seems like it's a stalling maneuver on behalf of the defendant to once again delay the resolution of his cases. The delay involved in handling these 3 cases is unacceptable in the view of the court. And I think both sides, and perhaps previous judges on these cases, are responsible for not seeing that these cases were appropriately moved through the system. What the court wants to see is progress toward case resolution, or let's get these set for jury trial. And as far as this court's concerned, we can try these consecutively on consecutive days before different juries, if that's what it takes to get these cases resolved. I have heard time after time that there is some global or comprehensive plea agreement in the works. It never happens. Now, when it appeared that Mr. Andrews was on the brink of getting that, Mr. Fellmeyer changes counsel. Now, Mr. Rapp, you, the delay in handling these cases are not attributable to you and your firm. You are new to the cases, but I will hold you responsible from this point forward toward any delays in getting these cases resolved, or at least announced for what it takes to get these cases disposed of. Instead of, we're working on a plea agreement, but we're not ready to announce it yet. Time after time, that's what the court hears, and this court is very frustrated with the lack of progress on these cases, which again, I say is attributable to both sides. So if you're going to get these cases resolved, counsel, get them resolved. I'm going to set one more court date for purposes of announcement of disposition in this matter. One more. So whatever you need to do on your respective sides to get these cases resolved, do it. Talk to whoever you need to talk to, including each other and including attorney with client. And let's get these cases announced for what they need to be announced for to get them taken care of. If it's trial announcement, so be it. But I will move these cases up in priority, and we will get these cases before a jury quickly, if that's the announcement. Mr. Fellmeyer, when I tell you where to appear for court, you appear where I tell you to. You understand?
Yes, Your Honor, I apologize.
Your attorney was very frank with this court this morning. Apparently, he ultimately misled you into thinking that you could appear in his office. This court did not approve that, and he has no right ever to change what this court orders you to do.
Yes, Your Honor.
But that now understood. Counsel, I'm going to propose Friday, March the 29th at 2:00.
You're all right. The state will make that work.
Okay. I want to
As
try to
will
get
the
ahead of
defense,
any
Your
show
Honor. Do you-
cause docket you might be involved in. Hopefully, we could get an announcement done in 30 minutes, whatever it is. Mr. Rapp,
Do you want Mr. Fillmeyer present there at the Judicial Center or here?
I want him at the Judicial Center.
Yes, sir.
It will be done by Zoom, Mr. Rapp. Your choice of participation location, that's up to you.
Yes, sir.
I do note, though, that's going to be right in the middle of a first appearance docket, just about ready to start a show cause docket. I'm just going to have to ask for the indulgence of court security on that date. Maybe they can set up a separate location for you and your client, Mr. Rapp, if you appear at the Judicial Center. They've been very accommodating in that regard.
Yes, sir.
Counsel, this court could have negotiated a settlement between Israel and Hamas by now. Surely, over the course of the next 5 to 6 weeks that this court is allowed, you can have the discussions which are necessary to make a better announcement to the court than the lack of progress announcements that I've heard time after time after time. So, thank you, counsel, for any efforts you make in that regard, as soon as you can make them. I'm not even adverse that if you do reach some comprehensive plea agreement, that you contact my assistant for an earlier court date. Otherwise, we're set Friday, March the 29th at 2:00 p.m. for further proceedings on all of these cases. Mr. Sweeney, anything else we need to announce currently?
No, Your Honor. Thank you.
Mr. Rapp, anything further at this time, sir?
No, sir.
Very well. And if there's nothing further, the Dylan Fellmeyer matters will currently be in recess, and this meeting may be ended for all at this time.
Thank you.
Judge Rickie 2024. Am I right? Oh my gosh. And I swear, when he coughed, I heard him cough something.
All right, let's go on the record in the matter of the People State of Michigan versus Seth Harberson, file 242408EX. Mr. Harberson, would you state your name, please, for the record?
Yes, sir. My name is Seth Gage Harberson.
Okay, and appearance, please.
Taylor Michelson appearing on behalf of Mr. Harberson for purposes of arraignment. We've reviewed the fugitive charges and waived for extradition at this time.
Mr. Harberson, you reviewed this matter, and I'm looking at it here, and it appears to be a matter that you signed, indicating you wish to waive your right for extradition and to have this matter move forward. Is that true?
Yes, sir. I just want things to go smoothly as possible. I'm not trying to fight anything.
Hold on, sir.
Yes, sir. I'm sorry.
I just want to make sure, and I'm not trying to be rude, sir. I'm just trying to make sure that you don't inadvertently say something that is injurious to your ability to defend yourself as you go forward. Okay, so I don't want you to say anything that could potentially be used against you, because we're on the record. All right. So let's just be as safe as we possibly can, and let me just ask you a few questions, and you can just explain to me. Well, you preferably say yes or no for most of them, but you understand you have a right to proceed to a extradition hearing on this matter and require the prosecutor or the state of Indiana to present a basis for us to proceed with this extradition. You understand that?
Yes, I do.
All right, and you understand that if you waive this matter, there's not going to be an extradition hearing. You're going to, I'm going to go ahead and sign this if I approve this, and that's going to set in motion Indiana coming to pick you up, and then you'll be able to proceed with dealing with matters in Indiana. Is that what you understand to be the case?
Yeah, I just want to get home. I just want to get this done over with and get home as quick as possible.
Oh, okay. All right. I get that. No one's pushed you or forced you or intimidated you?
No, I'm honestly scared out of my life right now. I don't know what to expect.
Well, let me ask you about that fear. Are you frightened to the point that being frightened is forcing you to do this, or are you saying you're just afraid of what you have to face there?
I'm just more afraid of just what's gonna happen. I don't know what's gonna happen. I don't know anything about any of the laws. I don't know anything.
Okay, I understand that. And that's, I understand that because these are serious, I get it, there are serious charges being brought against you, but as far as making this decision, no one's tried to frighten you or force you to do it here. Is that right?
No, sir.
And you understand that, no one's going to intimidate you or hurt you or harass you if you decided you wanted to challenge the extradition.
Yeah, but there's a chance that if I do that, it could be worse in that long run or whatever. Indiana courts.
That's possible. That's possible, but I want you to make a decision based on what you think is in your best legal interest, sir. You think that this is in your best legal interest?
Yeah, I am the one that got caught with the drugs. I did get in trouble with drugs. And
so let's just, I don't want you to speak to
yeah,
the
I
things
understand.
Don't make statements that might potentially hurt your ability to defend yourself, okay, sir? I'm just trying to protect you, all right?
Sorry, I'm trying to get up, dude.
Okay, I get it. You want me to sign this waiver of extradition so you can move on and proceed to deal with this, is that right?
I just want to go over to my family.
All right, is your family in Indiana?
No, I'm from Michigan. I'm from Felm.
All right,
I have a dog, my mom.
Okay.
44 acres. I just want to go home.
Judge is a dog. Just let him go.
All right, well, you understand that if I sign this waiver, you're not going home. You're going to be going to Indiana. You understand that?
I know, but as soon as I get to Indiana, there's a possibility of getting either a PR bond or probation very soon.
Okay, and that's possible. I don't know. I can't speak to what they decide to do, but that sounds possible. So you want me to sign this then?
I just want to get this shit done over with, sir. I'm sorry for the swearing. I just want to get it done over with.
But the answer is yes. Is that what you're saying?
Yes, sir.
I'm not trying to torture you, so I just want to make sure we have it clear on the record. All right, I will go ahead and sign this. And what I'm gonna do is I will make a notation in the file that they are to check on this so that we make sure that Indiana's followed up on it within 10 days, okay?
All right,
And that's just so that they just don't leave you sitting.
all right, thank you.
All right, good luck to you, sir. You're all set. You can leave the court.
All right, thank you.
Judge Belargin,
Yes.
are you revoking bond or are you leaving it at the 25,000?
Bond is continued.
Thank you.
Well, actually, wait a minute. We have extradition. He can't bond out. I'm gonna revoke bond completely.
Thank you.
All right, and Joe there, your name, please.
Tyler Rayleigh Bruce Hopson.
Mr. Hopson, this is a misdemeanor file 241638 SM. I'm gonna read it to you.
Taylor Michelson appearing on behalf of Mr. Hopson for purposes of arraignment. We reviewed the charges and waive a formal reading. Mr. Hopson will enter a plea of not guilty and he does not qualify for a court-appointed attorney.
Okay. Sir, you understand that then, that you are either going to represent yourself or hire an attorney on this matter? You are not represented by the public defender?
Yeah, I do, Your Honor.
Now, normally a case like this would always have a PR bond, meaning you wouldn't be sitting in jail. Yours did have a PR bond. You're sitting in jail because you already missed a court date. Now, on this, because it's a trespass case with a low threshold for penalty, I'm willing to put that back to PR bond because you're telling me, of course, you understand it's important to show up for court, and you will show up for court, right?
Yes, Your Majesty, and I don't want to explain because of getting any breaks or cuts, but I've been having a lot of mishaps deal in life right now. I just had my whole
Mr.
almost my
Hopson?
house.
Let me ask you this, Mr. Hobson. You're getting what you want. You could only screw it up. You might as well stop talking, right?
Yeah, you're
I just wanna make
absolutely
sure-
right.
I just want to make sure this is a good address for you.
Yes, that is a good address.
All right, so I'm putting it back to PR bond, which means you're gonna get out of jail soon. They should hand you a court date when you're leaving jail for courtroom B. That'll be the next time you're doing court, probably even only over Zoom. But you need to make sure you're there for that, because if it happened again that you didn't show up, you wouldn't be getting a PR bond, you'd just sit in jail, all right? So make sure you show up for court, but we're all set for what we need to do right now.
Thank you, Your Honor.
The face of the defense attorney when he said Your Majesty was so cute. Like she was holding back the laughter. It was adorable. Be safe, be well, sleep sweet, and much love.